Well, good morning, everyone. Welcome to the Supreme Court hearing in the appeal of Chubb against Enka. I'm joined on the panel this morning by Lord Sales, Lord Hamblin, Lord Leggett, and Lord Burrows. My name is Brian Kerr. Appearing for the appellant, we have Mr. David Bailey, QC, Mr. Tuvie Landau, QC, Mr. Marcus Mander, and Ms. Claire Ben. For the respondent, we have Mr. Dicker QC, Mr. Joseph QC, and Mr. Venkatenan. We'll start with Mr. Bailey. Yes, Mr. Bailey.
Good morning, my lord.
Good morning.
Can I start, my lord, with this remark, namely to thank the court on behalf of both parties for accommodating this appeal on an expedited basis during the course of this term.
Not at all.
My lords, as you will have seen from the written cases, this appeal involves two headline issues. The first is whether or not the arbitration agreement is subject to the same proper law as the construction contract. And secondly, if, as we submit, the answer to the first question is yes, and that the arbitration agreement is therefore governed by Russian law, then the second headline issue is whether or not the Russian courts should be prevented by way of an anti-suit injunction against my clients from exercising their jurisdiction under their treaty obligation under Article 2.3 of the New York Convention to determine whether the dispute of which they are seized falls within the scope of the arbitration agreement properly construed according to Russian law and therefore should be referred to arbitration. So those are the two key areas of the appeal. And so your lordships know where I'm proposing to go. I'm planning to address the proper law issue this morning and the injunction issue this afternoon. And Mr. Landau will follow, and the primary focus of Mr. Landau's submissions will concern the relationship and the alleged overlap between the curial law at the seat of the arbitration and the substantive proper law which governs the arbitration agreement contained within the construction contract. Now, my primary burden, my lords, is the rather turgid one of taking your lordships through the key authorities that shed light upon the proper approach to determining the proper law of an arbitration agreement. But before I embark on that exercise, can I raise an anterior issue, which is the practical and commercial consequences of the Court of Appeal's decision? Now, as your lordships know, what the Court of Appeal concluded is that the construction contract itself is governed by Russian law, but the obligation to arbitrate contained within it is governed by English law. Now, while that may appear, superficially at least, to be a coherent interpretation of the contract, it does give rise to a series of consequential practical and commercial questions to which the Court of Appeal's analysis gives no easy answer. Now, can I give three examples to explain what I mean? And the first question is a relatively simple one, and it's this: what terms of the contract constitute the obligation to arbitrate? Now, in order to answer that question, one has to look at the contract, and we have that in the bundles, in the core bundle at bundle A, and buried deep within the contract, we will find clause or article 50.1. Perhaps I'd ask your lordships to turn that up. It's at page 575 of the core bundle.
Yes.
At page 575, article 50 is headed or entitled Resolution of Disputes, and 50.1 contains a series or two obligations and an option followed in the last sentence of that subparagraph, the following words: if the matter is not resolved within 20 calendar days after the notice referring to the matter to appropriate higher management or such a later date as may be unanimously agreed upon, the dispute shall be referred to international arbitration as follows. And then there are 4 bullet points, one of which is that the place of the arbitration shall be in London, England. Now, reading the contract, it is, I would say, possibly self-evident that the last sentence of Article 50.1, which I've just read, constitutes the obligation to arbitrate. And according to the Court of Appeal's judgment, that obligation is governed by English law. But if that's right, it does raise these questions. What about the other obligations that appear in Clause 50.1? The obligations to undertake to make in good faith every reasonable effort to resolve the dispute, the obligation to send notifications and to have meetings. Those ADR, if I may call them that, obligations are clearly related to the obligation to arbitrate, but they are distinct, and one might think they are governed by Russian law because they aren't part of the arbitration agreement itself. Now, the Court of Appeal's answer is, well, actually, Clause 50.1 is indivisible, so that all the obligations that are set out in Article 50.1 constitute the obligation to arbitrate and therefore are governed by English law. Now, in my submission, that's not necessarily self-evident when one reads the contract as a whole. But even if it's right, so far as Article 50.1 is concerned, that in itself gives rise to a series of other difficult questions. For example, and I've got 2 examples. If, for example, the word notification in Article 50.1 is governed by English law, the question arises as to what did the parties intend that clause to mean, and whether it was to have the same meaning as the definition of notices and notifications contained in Article 51.4, which we see at page 577, which, so far as I'm aware, nobody has suggested is governed by any law other than Russian law. The same question arises in relation to the use in Clause 50.1 of capitalized terms such as agreement, works, and so on, and indeed the concept of good faith, which appears elsewhere in this contract. And the question again arises, which my submission has no easy answer, is whether those terms, when used in Article 50.1, are to be given the meaning accorded to them pursuant to Russian law or pursuant to English law. The further point in this context is Article 50.2, which falls after the obligation to arbitrate and provides, unless otherwise explicitly stipulated in this agreement, the existence of any dispute shall not give the contractor the right to suspend work. Now, based on the Court of Appeal's analysis, it's not clear necessarily why or if that right should be governed by English law as opposed to Russian law, given that it is independent from, or at least not self-evidently part of, the obligation to arbitrate. Now, none of those questions that I've been asking would arise for consideration if the reality is that the proper law of the whole contract, including those obligations to arbitrate, are governed by Russian law. And the particular dilemma of the Court of Appeal's decision arises when you look at other clauses in the contract, and in particular, if I could draw your attention to Article 42.2, and that appears on page 563 of the electronic bundle. Now, 563, it forms part of clause 41, sorry, 42, which at page 562 is entitled change of scope. And the important point is on page 563, a third of the way down the page on the right-hand side in English, there's a clause that provides that if the customer disagrees with the terms and conditions proposed by the contractor in response to the request for change, and so on, the contractor may then refer such a dispute, the word dispute in this paragraph is not capitalized, such a dispute for arbitration. If the customer disagrees with the terms and conditions proposed by the contractor in response to that request, and so on, then there's a reference to a notification, and at the end of this clause, the words appear, and the contractor may then refer such a dispute for arbitration pursuant to clause or pursuant to Article 50. Now, again, the difficulty that arises is that nobody, as far as I'm aware, and certainly not the Court of Appeal, has suggested that that clause is governed by any law other than Russian law. And if that's right, a real potential difficulty that arises as a result of the Court of Appeal's decision is the interplay between that clause governed by Russian law and clause 50.1, which the Court of Appeal has found is governed by English law. Now, the reality is, in my respectful submission, that what we see when we look at the contract as a whole is that the arbitration obligations, however you define them, are not hermetically sealed from the other obligations that appear within the context of the contract as a whole. The reality is that the arbitration agreement, as I say, is buried deep inside the contract. And in my respectful submission, it forms an integral part of the same contractual set of obligations. And that's a very strong pointer in my submission to the right answer, which we submit is that the arbitration agreement and the balance of the obligations contained within the contract must all be governed by the same system of proper law. Now, the reason I'm raising these questions at the very outset, before looking at the more legal issues in relation to presumptions and the like, is that the analysis I've just undertaken, which is a relatively short one, perhaps reveals the truism in Edwin Peel's article, which you very kindly sent through this morning, that the relative weight to be afforded to either the proper law of the main contract or the curial law of the arbitration agreement may well depend for its answer upon the facts of each case. And in particular, the construction of the contract as a whole and the relationship between the arbitration agreement and the obligations it contains and the obligations on the parties otherwise set out within the same contract. We can debate, and of course I will be taking your lordships to the authorities, the various significance of the presumptions that have been suggested, such as the presumption in favour of the main contract law in South America, or the presumption favoured by the Court of Appeal in this case in favour of the curial law. But ultimately, in the final analysis, this may be one of those cases where, responding to the question that Lord Clark was famously remembered for asking counsel at the bar, namely, isn't this case all about a point of construction? Well, the answer may, in fact, in this particular case, be yes. And in saying that, it chimes with what Lord Neuberger said in Sul America itself, where, having recognised the obvious tension between Lord Justice Morbick's analysis and that in Sul America and that of Lord Justice Longmore in C&D, said that ultimately there's no reason necessarily to overrule one or the other, because the question is ultimately one of construction. The relevant paragraph I have in mind is paragraph 51 of Sul America. I believe it's at page 1148. of the bundle. If I could ask you, Lordships, kindly to just turn that up.
Yes.
It's at the bottom of page 1148, my lord. Beginning at paragraph 51, given the desirability of certainty in the field of commercial contracts and the number of authorities on the point, it is at least at first sight surprising, but it is by no means easy to decide in many cases whether the proper law of the arbitration agreement is 1, that of the country whose law is to apply to the contract, or 2, that of the country which is specified as the seat of the arbitration. However, once it's accepted that that issue is a matter of contractual interpretation, it may be that it is inevitable that the answer must depend on all the terms of the particular contract when read in light of the surrounding circumstances and commercial common sense. Now, ultimately, that paragraph may encapsulate the route to the right answer in this case. And in my respectful submission, adopting that approach leads inevitably, we would submit, to the conclusion that on the construction of this particular body of rights and obligations, the obligation to arbitrate cannot properly be sliced off without leading to confusion and uncertainty. Now, my lords, against the background of that sort of introductory analysis, can I turn to the authorities? Because there obviously is a body of learning on the questions that your lordships have to consider. And if I may, I'd like to take you to the most important of those and make my submissions on them. The first, in terms of the chronology, is a case of the Court of Appeal decided in 1884 called Jacobs and Credit Lyonnais. And it's at the main appeal bundle at tab C63, page 3247. If we look at the head note, my lords, the case involved a claim for short delivery of Algerian esparto. I had to look up on Wikipedia what esparto were, but I'm
What are they? Don't keep us in suspense.
Well, my lord, I'm reliably informed that it's a form of grass fibre which is used in basket weaving. But,
I see.
Be that as it may, the contract provided essentially for the shipment of Algerian esparto from Algeria, and it was common ground that French law was the applicable law that applied in Algeria. And the question arose, well, if the contract is governed by English law, what is the relevance of French law to the obligation to make shipment, given the fact that the defendant said that as a result of French law, they're entitled to a defence of force majeure. Now, the judgment of the Court of Appeal was given by Lord Justice Bowen, and if I could just take you to the key parts of that. At the bottom of page 3257 of the electronic bundle, page 599 of the report itself. And he asked the question in the sixth line up from the bottom. The first matter we have to determine is whether this contract is to be construed according to English law or according to French. To decide this point, we must turn to the contract itself, for it is open in all cases for parties to make such agreement as they please, as to incorporating the provisions of any foreign law with their contracts. What is to be the law by which a contract, and then there's this important point, comma, or any part of it, comma, is to be governed or applied, must be always a matter of construction of the contract itself, as read in light of the subject matter and the surrounding circumstances. Now, why that particular paragraph is relevant is because it's often cited as authority for the fact that in English law, there's no conceptual objection to the French doctrine of dépassage, which effectively means that the parties are free, if they so choose, to apply different systems of proper law to govern differing obligations contained within the same contract. Now, having made that point, Lord Justice Bowen goes on to consider the relevant factors that applied to the conflict of laws analysis in the 1880s, and came to the conclusion, as we see at page 3259, at the bottom of page 601 of the report. He says, in the present case, the contract was made in London between merchants carrying on their business in the City of London, and payment was to be made in London. Presumably, therefore, we should infer that this was an English contract and intended to be governed by English law. But it still remains to be considered whether anything in the contract itself or in the nature of its stipulations displaces its prima facie view either wholly or in part. So again, the words in part there contemplate the possibility that the parties may have intended a separate section or separate set of obligations contained within the agreement to be governed by a different system of law. So he then goes on, now it cannot be contended that the parties have in express terms provided that any portion of this contract is to be construed or applied otherwise than according to English law. And we would submit that's again true here. It would have been open to the parties, had they so wished, to include a specific provision in Article 50.1, providing that the arbitration agreement contained within it was governed by English law. But there is no express choice in our case, just like there was no express choice in Jacobs and Credit Lyonnais for a separate system of law to govern particular individual obligations contained within the contract as a whole. So he goes on to consider, therefore, in the absence of an express choice, whether in the circumstances of the case it's possible to infer that the parties must have chosen for the obligations in relation to the shipment from a port where French law applies, that obligation is properly to be inferred as being governed by French law as opposed to English law. And having considered the various considerations put by the parties before the court, he deals with that point, the last paragraph of page 3260, and he says there's absolutely nothing in any part of the contract, as it appears to us, which can amount to an indication that it is in any way or in any part of it be treated as anything except an English contract. And then he goes on to deal with the fact it's a shipment of esparto from Algeria. And then the key sentence at the bottom of this paragraph, to hold that on this ground only, the ordinary presumption is to be displaced, and the parties must have meant some law other than the English law to govern the construction of any portion of the contract as regards the liabilities of the contracting parties, will be to introduce a serious element of uncertainty into mercantile contracts. And at the very end of the judgment, he says, page 3262, if they wanted to achieve that outcome, they should have done so in express terms. Now, again, in my respectful submission, that chimes with the analysis I undertook first thing this morning, in that the conclusion reached by the Court of Appeal as to how one slices and dices the construction contract between English and Russian law does give rise, on the facts of this particular case and the contract which you have to construe, considerable commercial uncertainty and difficulties, all of which would be avoided if Russian law were to govern the entire contract. And as I said this morning, that points in my submission strongly to the conclusion that the parties intended the main contract law to govern the entirety of their obligations contained within the contract. The point of principle which that case also demonstrates in my submission is that the presumption that a contract is governed by a single proper law will only be displaced or rebutted in a case of an express choice of a different system of law, or in exceptional cases where an implied choice to that effect can be inferred. But they will be, in my submission, rare and exceptional. And that latter point is consistent, we would submit, with the general, if I may call it this, presumption against depassage, which is inherent in English law and perhaps best illustrated by a dictum from Lord McDermott in a case called Carla and Midland Bank Limited, which I hopefully will have been added to your Lordship's electronic bundle and has page number 7583. And in that case, Lord McDermott said this. He said, though there is no authority binding your Lordships to the view that there can be but one proper law in respect of any given contract, it is doubtless true to say that the courts of this country will not split the contract in this sense readily or without good reason. And my lord, that again we would submit as a useful guide in considering whether or not it can properly be said in this case that the parties made an implied choice of English law to govern one discrete part of it, rather than the main contract law of Russian law, which governs the balance of the obligations. Now, the next case in the chronological run is a case called Hamlin and Tanisher. And that was a decision that, or a case that began in Scotland and went to the House of Lords. We have in the bundles both the decision of the Court of Scotland, I think it was the Court of Session in Scotland, as well as the decision of the House of Lords in London. And it does assist, if I may say so, if we look at the Scottish decision first, before looking at what the House of Lords itself had to say. Perhaps I could ask you to turn it up. It's at page 1153. Of the electronic bundle. And if I could just draw your Lordship's attention to certain features of this particular decision. What we get out of the head note at page 1153 is that the case concerned a contract for the sale and supply of grain and machinery, and the contract included a particular clause that is set out in the first paragraph of the head note as follows, quote, should any dispute arise out of this contract, the same to be settled by arbitration by two members of the London Corn Exchange or their umpire in the usual way. Now, the issue that faced the Scottish court is whether or not to enforce that obligation to arbitrate. In other words, it's essentially the equivalent of the Section 9 jurisdiction that we have under the Arbitration Act to grant a stay to arbitration pursuant to Article 2.3 of the New York Convention. And as the head note reveals, the Scottish court decided not to grant a stay. And the reason for that is because they reached the conclusion that the arbitration agreement was governed by the same system of law as the contract as a whole, which had been determined by reference to the doctrine of lex loci solutionis as being Scottish law. And the second ground being that the arbitration clause could not be regarded as a separate contract, and for that reason it was void as a matter of Scottish law and could not be enforced. Now, as far as the reasoning is concerned, Lord Adams' judgment doesn't greatly assist. He essentially appears, and this comes from page 1157 of the bundle, it's the paragraph just before Lord Maclaren. He doesn't offer much analysis other than it's implicit in what he says, that he regarded the contract as an indivisible one, governed by a single system of law, which was Scottish law. Lord Maclaren, however, has a some more sophisticated approach to the question. He, at the bottom of page 1157, concludes that on the basis of the conflict of laws principles applicable in Scotland, that Scotland must be taken to be the locus solutionis, and therefore, as a consequence, Scottish law is the proper law of the contract as a whole. But then at page 1157, he turns to the arguments that have been advanced by the defendants. And these are quite informative, particularly given what we just looked at in Jacobs and Credit Lyonnaise. If I could ask you just to look at 1157-59, I think it's the third paragraph down beginning, sorry, my Lord Sales? Sorry, I apologise. I was trying to keep an eye out for hands, and I
yes, that's all right. But,
if I could ask you to look at 1159, opposite the top hole punch, if you have it in hard copy, or the first main paragraph, or sorry, actually the second paragraph, but it was maintained by the defendants. There are 2 points that he refers to. The first is that the arbitration clause be regarded as an independent contract. And then the second point is that reliance was placed on the case we looked at first, namely Jacobs Lyonnaise, to the effect that it's open to the parties to a contract to make any such agreement as they please, as to incorporate the provisions of a foreign system of law into their contract. And he dealt with those 2 points in relation to the first point. He dealt with it halfway down the page. He says, now taking the defendant's arguments as I have stated them, my opinion on the first point is that the agreement to refer disputes to members of the London Corn Exchange is not an independent contract to be performed in England, and therefore to be governed by the law of England. I think it is a stipulation ancillary to the contract of sale. One test of independence is whether the provision is capable of standing alone, or whether any effect could be attributed to it if the contract of sale to which it is annexed were displaced. But it is plain that the clause of arbitration would have no meaning if it were detached from the contract of sale, because it is a clause of reference of disputes arising out of that contract. So essentially, even in 1893, the doctrine of separability had been rejected as a sound basis on which to approach the analysis as to the conflict of laws in this context. And as far as the second argument is concerned, he essentially concluded that it failed for the same reason as the first. And one can see that from the last paragraph of his judgment at page 211 of the internal pagination and page 1160 of the electronic bundle, where he rejects the Jacobs Credit Lyonnaise argument on the basis of the, I think the last full sentence before the second from last sentence. And then he says he can't accept it unless I could regard the arbitration clause as an independent stipulation, which for the reasons stated in is a view I'm unable to accept. So he ruled out both depassage based on Credit Lyonnaise and also the idea that separability could provide a basis on which to infer or conclude that the arbitration clause was either expressly or impliedly governed by English law. Now, Lord Kinnear dissented, and he reached an opposite conclusion. At 1160, towards the bottom of the page, you'll see reference to the Jacobs and Lyonnaise case, where he recognized that it's possible to have depassage as a concept. And page 1162, the heart of his reasoning is in the middle of page 1162, where he says the argument is that all the substantive obligations of the contract for the purchase, treatment and delivery of the grains in question are to be performed in Scotland and must be governed by the law of Scotland, and therefore that the ancillary obligation to refer disputes to arbitration must be governed by the same law, because two different systems of law cannot be applied to the main contract. Now he rejects that as a final conclusion for two reasons, one of which is the fact he regards it as less weight, given the fact that English law and Scottish law are essentially identical, save in relation to the validity of the arbitration agreement. And then he reaches his conclusion, which he says the more correct view seems to me to be that the agreement for arbitration is a distinct collateral agreement, and that the question we are to determine is whether it was the intention of the parties that the agreement should be carried into effect by an English or a Scottish arbitration. And then he says a second analysis, even if the contract is indivisible and separability isn't the answer, he basically raises the possibility that the whole contract must be governed by English law. Otherwise, the arbitration agreement which the parties entered into is rendered invalid. So that was the dissenting judgment. The majority view was, notwithstanding the fact that the arbitration agreement was invalid under Scottish law, it was not possible to justify a basis, even on the grounds of invalidity, to infer or conclude that the parties had either expressly or impliedly contracted on the basis that the arbitration agreement was governed by English law. And that's the background before the case went to the House of Lords, and that happened in 1894, and we have the decision of the House of Lords in Bundle B, tab 14, page 985 of the main appeal bundle. And it's an important decision on which my learned friends place considerable weight in their analysis and argument. And obviously, it's like I'm not going to read the whole case, my lord, but I will invite your lordships to study it in due course. But at this stage, if I may, what I'd like to do is make 5 points about the features of this case, which in my submission are significant. Now, the first of those 5 points is this, namely that the House of Lords recognised that there was no choice of Scottish law in the main contract. In other words, there was no express or there was no implied choice of Scottish law for the contract as a whole. And we see that from Lord Watson's speech, page 994. To 995, where he explains that the rule in relation to lex solutionis is essentially the default rule that arises in circumstances where the parties have not made a choice, express or implied, for the proper law of the contract. So, in my respectful submission, my own friends are mistaken when they suggest at paragraph 42.1 of their written case that this decision in Hamlin is to be regarded as a case where there had been an implied choice of Scottish law in relation to the main contract. There hadn't. The reason the courts had decided the proper law of the main contract was by reference to the default provision that applied in the absence of choice. Now, the second point I want to make about this case is that one has to be cautious in how one approaches it. And the reason for that is for 2 points that were made by Lord Wilberforce and Lord Diplock in the Tunisienne case, which we'll come to in due course. We don't need to turn it up now, but if I can give you the references in Lord Diplock's speech at page 807 of the electronic bundle, where he pointed out the fact that in earlier cases there'd been a failure properly to distinguish between the proper law and the curial law, and also a failure to properly distinguish between the various different limbs forming part of the common law test. And then the second cautionary note sounded by Lord Wilberforce in relation to this specific case at page 799 of the bundle, where he said that the case must be approached with caution, so great have been the changes in private international law since 1889. And he said that in 1971, and that was obviously nearly 50 years ago, so it's certainly true today. Now, the third important feature of the Hamlin case, which is very different to ours, is that a key feature of the arbitration clause in that case was not the choice of seat, which in one sense hadn't even been expressly identified, but rather the fact that it specified that the arbitrators would be members of the London Corn Exchange and that they would settle the dispute in what was described as being the usual way. Now, my lords, in my submission, they are additional factors or features of the arbitration clause in the Hamlin case, which don't arise in our case, which can lead to the conclusion, as we'll see, that that clause was governed by English law. Now, the fourth point I want to make is this, that while I accept that the reasoning is not entirely clear, in my respectful submission, the correct interpretation of this case is that the House of Lords concluded that the arbitration agreement, which I've just read to you, Lordships, governed by English as a matter of express choice. In other words, this isn't a case where, contrary to Lord Justice Bowen's dictum in the Jacobs case, the court felt it was possible to infer depassage. Rather, this is a case where, properly construing the arbitration clause itself, the court was able to conclude that there had been an express choice of English law to govern that particular clause. Now, there are three reasons we submit that that is the correct interpretation. The first of which is, one looks at page 991, and in particular, this is the speech of Lord Herschel. That's page 208 of the internal pagination. He begins halfway down the page, he begins the paragraph by saying, now in the present case, it appears to me that the language of the arbitration clause indicates very clearly that the parties intended that the rights under that clause should be determined according to the law of England. As I've said, the contract was made there, one of the parties was residing there, where under such circumstances the parties agree that any dispute and clause, he says, it seems to me that they have indicated as clearly as it is possible, so as clearly as it is possible, that their intention that that particular stipulation, which is a part of the contract between them, shall be interpreted and according to the governed by the law not of Scotland but of England. And the important further point he makes to justify that conclusion is the fact that the clause would have been invalid as a matter of Scottish law. And that is a strong pointer. In fact, he says it cannot have been the intention of the parties to contract on the basis that that particular clause would be invalid under its proper law. And at the top of page 209 of the internal pagination, the top of 992, he says, I see no difficulty whatever in construing the language used as an indication that the contract or the term of it was to be governed and regulated by the law of England. Now, further support for the analysis that this was regarded as an express choice of English law, not an implied one, appears in Lord Watson's speech at page 995 of the appeal bundle at the bottom of that page, where he says, in the present case, it does not appear to me to be necessary to discuss the relative value of these considerations, because in my opinion, the clause of reference is expressed in terms which clearly indicate that the parties had in contemplation and agreed that it should be interpreted according to the rules of English law. The second reason, my lord, why my submission this is the right analysis is because although Jacobs and Credit Lyonnaise was not actually referred to in the judgments of the House of Lords, we do see from page 987 that was the key case that was presented by the advocates on behalf of the appellants. You see it, page 987. And it may well be that the House of Lords had very much in mind Lord Justice Bowen's observation that depassage is not likely to be inferred and is properly regarded as something to be determined by way of express choice. And then the third, and perhaps the most compelling basis for my submission that this is properly to be interpreted as a case of express choice affecting depassage, is that that is exactly how it was interpreted by Dicey in the first edition of his very famous work on the conflict of laws, which was published 2 years later. But in that respect, perhaps I can ask you to look at that passage. It's paragraph, or rather it's page 1444 at tab B36. And this is the section of Dicey's first edition, and perhaps you want to go back to it, back to the first rule, which this is a sub rule of, which is 1440, Rule 149, the interpretation of a contract and the rights and obligations under it, of the parties thereto, are to be determined in accordance with the proper law of the contract. And then sub-rule 1 at page 1444, sub-rules for determining the proper law of a contract in accordance with the intention of the parties. Sub-rule 1, when the intention of the parties to a contract as to the law governing the contract is expressed in words, this expressed intention determines the proper law of the contract and in general overrides every presumption. And sub-rule 2, which we see on page 1445, is when the intention of the parties to a contract with regard to the law governing the contract is not expressed in words, their intention is to be inferred from the terms and nature of the contract, with the general circumstances of the case, and so on. So sub-rule 1 and sub-rule 2 effectively encapsulate the first and second limb of the common law test. The important point, of course, which is obvious, is that of the two illustrations given under sub-rule 1 of express choice, the second illustration that's given at the top of page 1445 is, one can infer from the way it's set out, but in particular from the footnote at little 1, is the Hamlin case that we've just been looking at. So in my respectful submission, the important features of Hamlin are there was no choice of law for the main contract, and the House of Lords approached the arbitration clause in that case on the basis that it had been subject to an express choice of English law. And the further feature of the case is that if in insofar as I'm wrong about that, it could be explained, contrary to Dicey's view, as being a case of an inferred choice of English law to govern the arbitration agreement. In other words, depassage by inference, deplored by Lord Justice Bowen, but not ruled out as a conceptual possibility. I accept that. If it is properly to be interpreted on that basis, then in my submission, the only justification for it is because the clause would have been invalid under Scots law, and that would be so contrary to the obvious intentions of the parties that it was legitimate to infer depassage by way of invalidity. Certainly, as we'll see in Tunisienne, Lord Wilberforce, when he describes the case at page 799, describes the case as being a decision on the validity of the arbitration clause. So, Lord, against that background, what our submission is that for the reasons I've sought to explain, the Court of Appeal at paragraph 100 of their judgment was wrong to treat Hamlin as an authority for the proposition that a choice of a London seat is an implied choice of English law as the proper law of a contract. That analysis, which is also endorsed by my own friends in their written case, is, in my respectful submission, one that affords greater weight to the Hamlin case than it can properly carry. And Lord, the second case is the House of Lords decision in Tunisienne, which is a decision from 1971, and it's in bundle volume 2, bundle B, volume 2, at tab 8, page 775 of the electronic bundle. Now, my lords, the Court of Appeal were undoubtedly correct to say, as they did at paragraph 72, that this case was concerned with the question as to the proper law of the contract as a whole, rather than just the proper law of the arbitration agreement. So that's undoubtedly correct. Nonetheless, in my respectful submission, it remains an important decision in the context of the present debate for at least the following 6 reasons. The first of which is that it at least proceeds in terms of analysis on the basis that there would be a single proper law for the whole contract, including the arbitration clause. There was no suggestion that I've been able to discern in any of their lordship's speeches that the proper law of the contract could be split so that the arbitration clause might be governed by English law, even though the proper law of the contract was French law. The second reason it remains of some assistance to your lordships is because the case assists in identifying the test to be applied in determining whether the parties have made an express choice of law. The reason I say that is because the majority reached the conclusion that clause 13 of the Charter Party in that case actually did amount to an express choice of French law, notwithstanding the somewhat inelegant way in which it was expressed. And the guidance in particular that I would refer you to is at page 608 of the internal pagination, page 811 of the electronic bundle. And this is a portion of Lord Diplock's speech where, opposite C on page 608, 811, he says, whether they succeeded in expressing that choice in words, which when read in light of the surrounding circumstances are sufficiently clear to enable the court to identify it, must be decided by applying the ordinary rules of construction of commercial contracts. So the test, as articulated by Lord Diplock for the first stage of the common law test, is did the parties succeed in expressing a choice of law in words which, despite the drafting, are sufficiently clear to indicate to the court or enable the court to identify a choice of law. Now, if you ask the question or ask that question by reference to the contract in this case, and in particular the applicable law clause, which is in the appeal bundle at page 593, I'm not sure whether you can have two documents open at once, so I apologise, but if not, you have the reference. It's 593. You probably will have seen it. It's the definition of applicable law, page 593, applicable law, and then on the right-hand side, one sees a reference effectively to the law of the Russian Federation. Now, the question is, when looking at the language that the parties used in the context of the contract as a whole, did the words they used, properly construed, convey a sufficiently clear choice of Russian law as the proper law of the contract? Now, essentially, it's a question of impression. It's a basic point of construction. There's not much I can do further than identify the point. But in my respectful submission, our case is actually much more straightforward in terms of express choice than the Tunisian case, where there was a real competition in terms of the Charter Party between French law and English law, and whereas the Court of Appeal found the choice of law clause, which the majority of their lordships concluded was an express choice of French law, was so opaque that they regarded it as meaningless. That certainly isn't and cannot be suggested on the facts of this case. Indeed, given the fact there is no realistic contender other than Russian law, when you come to construe the construction contract in its entirety, in my respectful submission, the words the parties used, particularly the applicable law clause, make it clear that those words, those manners of expression, properly understood, conveyed a clear choice of Russian law as the proper law. The third.
Can I just, sorry, Lord Diplock seems to be proceeding on the basis that the only alternatives are express choice or closest to most real connection, whereas the orthodoxy now, at least, is that there's also a category of implied choice or inferred choice and or demonstrated choice. And it would seem to me that this case, it's quite hard to say if between those two that this is an express choice, because it's very easy to say this is Russian law as the applicable law of the contract. But what's been done is to define applicable law as Russian law, and then it pops up in various places. So it might be better to say it's an inferred choice. But Lord Diplock isn't contemplating that intermediate possibility, as far as I can see.
Well, my lord, that's a very fair point. But in fact, if one looks at the House of Lords decision as a whole, one can see that in fact Lord Diplock aligns the first and second limbs of the common law test into what he calls stage 1,
Mm.
and one then moves on to stage 2. Perhaps I could just try and find that part of his judgment where he I think it's really at page 605. Well, actually, I think the clearest part is actually page 603 of his speech, which is page 806. In fact, it's between E and G, my lord. This is perhaps a better paragraph to refer your lordships to, given Lord Legate's question. At little E on page 806, Lord Diplock says, English law accords the parties to a contract a wide liberty to choose, both the proper law and the curial law, which is applicable to it. Then at F he says, the first stage, therefore, when any question arises between the parties to a contract, is to determine whether the parties intended by their contract to exercise any choice at all, and if they did, to determine what the system of law was. And the ordinary rules of construction. So he regards choice effectively as being part of the first stage. And if one can't then find any choice express or implied, then one goes on to the second stage, which is the default rule. Now, actually, and there may be better illustrations of this in the judgment. I'm sorry I haven't got them all immediately to my fingertips, but it's clear in my respectful submission that the Lord Diplock and the balance of their lordships in Tunisienne recognised that there were at least these two limbs related to the question of choice, namely whether the choice is made express or whether it's possible to imply or infer such a choice had been made. And you have to approach it on that basis before using the default mechanism. And if over luncheon I can find the even better reference in Lord Diplock's speech, of course, in answer to Lord Legate's question, I will provide the reference. But what helps, my lord, perhaps, from the point that Lord Legate raised in relation to the way Lord Diplock approached it, is that there is no qualitative difference, in my respectful submission, either conceptually or legally, between a choice made under the first limb of the common law test, namely an express choice, or the second limb, namely an implied choice. Both, in my respectful submission, are valid choices and conclusive choices of the proper law of the contract. And in other words, when one looks, as we will in due course, to Article 3.1 of the Rome Regulation, where in the same context of one paragraph there's reference to a choice either being made expressly or being clearly demonstrated, if one is able to demonstrate in a particular case that a choice has been made between, as to the proper law within the context of Article 3.1, it should, as a matter of analysis, the consequences of that choice should not depend upon whether it was done expressly or whether it was done by way of a clear demonstration. What matters is the fact that the parties have made a choice. And indeed, when we look at South America, my submissions will be to your lordships that the analysis that Lord Justice Morbeck embarks upon in that case is equally applicable in a case where there is a choice of law pursuant to Article 3.1 of the regulation, even if it's on the basis of clearly demonstrated rather than express. So I hope that's some assistance in response to my Lord Legate's question. But while we're on the common law test, there is a small minor point I want to make, which is this, that in relation to the three limbs, it has been suggested, and I think Lord Justice Morbeck picks up on this point, that the second limb and the third limb sometimes overlap, at least in terms of the considerations that are relevant to implied choice and those that are relevant to closest connection. And that's, in a sense, correct. However, I would like to remind you, lordships, and I'm sure you're familiar with it, of what Lord Justice Bingham said on that very point in a case called the Comenius S, which we have in bundle C58, without taking your lordships the whole case. If I can just point out the particular dictum I have in mind, it's at page, I think, 3184. 3184 of the electronic bundle. One's working from that. Yes, sorry, I beg your page 3185, but one does need to begin perhaps at the bottom of 3184 to see the context. Having referred to the two sub-rules in Dicey, namely sub-rule 2, which is the implied or inferred choice of law, and sub-rule 3, which is the default rule in relation to closest connection. Bottom of 3184, Lord Justice Bingham, as he then was, said, Mr. Collins pointed out that there is some overlap between the processes envisaged by 2 and 3, and Lord Justice Bingham says this is true and has the formidable support of Lord Wilberforce. There is nonetheless a clear difference in the purpose for which the surrounding circumstances are considered under the two sub-rules. Under sub-rule 2, it is to ascertain the parties' contractual intention, meaning their actual and not their imputed intention, what they would have said if asked at the time. Whereas under sub-rule 3, it's to determine objectively and irrespective of the party's intention what system of law is to be effectively the default provision that the law must provide. And bearing in mind one needs a default provision because as a matter of English law, one can't have a floating proper law. To have a valid contract, there has to be a proper law, even in the absence of choice. And while I'm on that topic, having read one of the articles that you very kindly sent through this morning, there was an invitation. I'm not necessarily advocating that you take it up, but an invitation to consider a whole revamping of the common law rules in this context. But one point that you might want to consider if you attempted to embark upon such a course is that one could see the force in an argument that in the context of arbitration clauses, that the default rule in English common law for this particular purpose ought to be the court of the seat. And the reason for that is because that would align the English common law perhaps more closely with that of the New York Convention, in particular Article 5.1a, on the basis that the Convention talks about choice, which of course lies at the very heart of private international law. Certainly in this century, it's embedded in the recitals to the regulation. It's a clear principle of party autonomy and so on. Choice is the key. But in the absence of choice, if one needs to have a default rule, then one can see the temptation in that article to reach the conclusion, well, actually, the default rule might be the law of the seat. But as I say, I'm not inviting you to take that course. It's something I read this morning. It's just crossed my mind that there would be at least some logic behind that position. Of course, on this particular case, our position, our appeal, is based on the grounds that there is a clear choice, either express or clearly demonstrated. And this case is properly to be decided on the basis of choice, not by reference to any default rule, either under the traditional rule or on the basis I've just suggested. Now, the fourth, sorry, going back to where I was, and I apologise for the slight diversion. Yes, my Lord, Lord Burrows.
Sorry, just to query what you've just said, I was just slightly puzzled in this sense that if you have decided that choice is not what is governing, that one is in the realm of a default rule, why would you regard the law of the seat as more obviously the default rule than the rule that would otherwise apply to the rest of the contract?
Well, that's a very good question, and perhaps an indication as why I perhaps shouldn't have been tempted by what I read first thing this morning to give the indication I did. But my Lord, you're quite right that if there is to be a default rule, it doesn't necessarily have to be an absolute one, and perhaps that would strike more accord with what Professor Edwin Peel said in his article, that each case depends upon its own facts, and therefore to have an absolute position probably would defeat that more nuanced approach, which would allow the courts to come up with a fact-sensitive solution, even at the default stage, that which would depend on the facts of each case. But in answer to Lord Burrows' question, the basis for a default rule, which is clear and simple as the one that one might be tempted to think would be appropriate, namely the law of the seat, is it simply creates certainty in the absence of choice. And that's probably the only reason for the suggestion I've made. And as I say, there is some support for some kind of analysis that treats the court of the seat as the default position from the, sorry, I seem to have lost Lord Legate.
Oh.
Ah, he's back.
Mm.
From Article 5.
Thank you.
My Lord, I hope that's some assistance. My Lord, the fourth reason, going back to my 5 points on, or rather 6 points on Tunisienne, the fourth point that arises in relation to Tunisienne is that it is authority for the proposition that a choice of seat is an implied choice of the curial law of the seat as the procedural law of any arbitration. It seems to me that's clear from Lord Diplock's speech at page 807 of the electronic bundle, page 604b of the internal pagination. And he also adds in that paragraph that an implied choice operates, he says, as if it were an express choice of the curial law of the contract. Now, we don't particularly quibble with that analysis, certainly in terms of its result, but what we would respectfully submit is that a slightly preferable way of putting the matter is the way in which Lord Mustall put it in Channel Tunnel at page 357H to 358A of that judgment, which is in the electronic bundle at page 762 to 763. At the bottom of 762, he says, little h, but the curial law must, I believe, be the law of Belgium. Certainly there may sometimes be an express choice of a curial law, which is not the place where the arbitration is to be held. But in the absence of an explicit choice of this kind, or at least some very strong pointer in the agreement to show that such a choice was intended, the inference that the parties, when contracting to arbitrate in a particular place, consented to having the arbitral process governed by the law of that place is irresistible. So that's the way that Lord Mustall put it, which is consistent with the way Redfern and Hunter analyse the application of the curial law. It's not so much a matter of choice, it's just a matter of inevitable consequence. Much in the same way as if we get, or if we're ever allowed to, again with any confidence, get on the Euro shuttle and go to France, we're not necessarily choosing French law to govern our holiday, but if we know if we rent a car and drive around France, we have to consent to the application of French speeding rules and all the rest of their legal provisions. That's the kind of difference between choice and consequence of other choices. And that consequence of other choices is actually the way that my Lord Hamblin analysed the point in, I believe it's called a case called Jagang, which also we have in the bundles at tab C96, page 4010 of the bundle. And in particular, is paragraphs 20, 21 and 22, page 4013, and paragraph 28 at page 4014. And in particular, my Lord Hamblin described effectively the choice of a place, or rather a seat, carries with it an implied choice as to the governing procedure. So this is a case where we can only infer by way of the second limb an application of English curial law from the base choice of seat. It's different from a case such as Excel and Corning, where you can have an express choice of English curial law alongside your choice of seat. But this isn't an express curial law case. Our case we're talking about, it's a case of an implied choice of curial law. Now, the fifth reason Tunisienne is important is because it also explains, in far as the arbitration agreement itself carries any implication as to a choice of proper law, it explains what the basis for that implication is. And in particular, the implied choice of a proper law from an arbitration agreement doesn't arise from the choice of the curial law of the seat. Rather, the implied choice of a proper law arises from the fact that the arbitrators at a particular seat would ordinarily be expected to be conversant with, in fact only conversant with, and apply their own national system of proper law to the substantive dispute between the parties. That is the rationale or the reason for the implication in the first place. And one sees that out, and perhaps we don't need to turn it up. I'm conscious of the time. We see that from Lord Diplock at page 807, 604H, and from Lord Wilberforce at 556B at page 799. Now, why that's important in the context of what implication can be drawn from an arbitration clause is that once one recognises that on any view the arbitrators are going to be applying a different substantive system of law from their own to resolve the dispute between the parties, such as this case, being common ground that the contract is governed by Russian law, it inevitably follows from that the arbitrators, were they to be deciding a dispute between the parties referred to them. Sorry, I'm just pausing for Lord Hamblin. I don't know if you can still hear me, but...
Yes, we've lost Lord Hamblin, hopefully momentarily.
Indeed, my lord.
Our IT department is contacting Lord Hamblin.
My lord, I'm in your hands, but
Well, shall we take a break for 5 minutes while we get Lord Hamblin restored?
my lord, certainly.
Yeah, let's do that.